I'm a solicitor with the Highland Council, and I take the lead on short-term let licensing for the council. I'm just going to kick off today by firstly giving a bit of information, some disclaimers. So the first one is that the presentation contains some responses to some frequently asked questions which the Highland Council short-term let licensing team have received. These responses are for general information and guidance purposes only, and they don't constitute legal planning or any other professional advice. All applicants should seek independent legal advice from their own solicitor as part of their application on any specific legal points. So that's the first one. The second one is that today's presentation is effectively on STL licensing. The presentation is not to discuss whether STL licensing should be in place or discuss the applicability or the scope of the legislation. Legislations ultimately come from Scottish Parliament, Scottish Government, and it's for them to determine whether any changes are required and make any changes to the scope or applicability if they considered that that was appropriate to do so. There may be some points which I can't answer today in our Q&A session. It's not that I'm trying to be unhelpful. It's just that some of the questions I just can't. I just will not be in a position to answer. I should also say the legislation is as at today's date, which is the 19th of September 2023. Any changes that could be introduced to the legislation or the deadlines are for the Scottish Parliament to advise on. They've told us that there are no amendments to the scope, applicability or deadlines. However, ultimately it's the Scottish Parliament's prerogative if they were to change this. So as I say, legislation is at today's date. As was mentioned at the outset, we'll record the first part of the presentation and we can have a Q&A at the end. I appreciate you may want to type questions into the chat box as we go along. What I'd appreciate if we could just send the questions on at the end, so you can maybe type them in the chat box as we go along, but once we've finished our presentation, if you can then just hit enter so that those questions can come on to me at the end. So without further ado, I'll kick off. So today's presentation will cover an introduction to short-term. So first of all, we'll look at the definitions and exclusions, look at the timescales for applying, look at the conditions on an STL licence, look at the application process in a bit more detail, go through the details of supporting documents that are required, details of declarations to be made, and discuss what happens if an objection is made. And then, as I say, we'll have a Q&A session. So I have got some frequently asked questions which have been asked at similar presentations which I've presented at on STL licensing, and these are peppered throughout the presentation itself, and we can follow up on those as part of the Q&A session. So in terms of the STL licensing team, so the main points of contact are myself, Gary Summers. I'm the solicitor who heads up the team, and I'm assisted by our licensing officer, Julie Trainer. We are both based in our Fort William office. However, we apply throughout the Highland Council area. So we have admin assistants and clerical assistants who are based in our Fort William, Inverness, Portree and Wick offices. So in terms of short-term licensing, so it's a mandatory licensing regime which was brought in by the Scottish Government and which local authorities were required to establish by the 1st of October 2022. Our licensing scheme has been in place since the 1st of October 2022, and indeed we've received a number of applications since that date. Now, prior to the introduction of the legislation, there was no requirement to license short-term lets, and therefore local authorities did not have the ability to regulate these types of premises. The licensing scheme was brought in by the Scottish Government with the aim to ensure short-term let premises are safe, to ensure people providing short-term lets are suitable, and to address issues faced by neighbours. So the short-term let licensing scheme covers a wide range of residential properties and includes, but it's not exclusively, self-catered properties, B&Bs, guest houses, glamping pods and yurts, and we'll go into this in a bit more detail shortly. So what counts as a short-term let property? So it is not based on how long someone is staying in the property, despite the term short-term let being used. It's not based on how long someone is staying in the property. Instead, a licence is required for the use of residential accommodation provided by a host in the course of a business to a guest where the following criteria are met. So this is the key. The guest does not use the accommodation as their only or principal home. Short-term lets entered into for commercial consideration, so that can include money, can include goods exchanged of money in lieu of money, such as a case of wine or a home swap. The guest not an immediate family member of the host, with further details of that being available on the slide. The guest is not sharing the accommodation with the host for education as approved by a school or college. The guest is not an owner or part owner of the accommodation. The accommodation is not provided for the provision of work or services by the guest to the host or to a member of the host's household, and the accommodation is not excluded by way of a list of exemptions. So now moving on to look at some of those properties which are excluded from requiring a short-term let license. So as we can see on the slide, there are apart hotels. Now they have a statutory definition within the STL licensing legislation. So that is that will apply based on the facts and circumstances of accommodation. So, notwithstanding the fact that you may call yourself an apart hotel, it has to come within the statutory definition of being an apart hotel to have the exclusion apply. We also have premises which have a liquor license and where accommodation is listed in their operating plan, and if the full extent of the STL license is contained within the layout plan, they'll be excluded from requiring an STL license. A hotel which is planning permission granted for use as a hotel, and I'll come on and discuss that in a wee bit more detail shortly. A hostel, which again has a statutory definition within the legislation. Residential accommodation where personal care is provided to residents, hospital and a nursing home, residential school, college or training centres, prisons, young offenders institutions, detention centres, refugees, student accommodation, and accommodation which otherwise requires a licence for use for hire for overnight stays. So in terms of other properties, other types of properties that are excluded from requiring an STL licence, accommodation which is provided by the guest. So for example, if a guest brings their own tent to stay in, accommodation which is capable without modification of transporting guests to another location. So for example, canal boats and yachts, they're excluded from requiring an STL licence. A bothy, and again, there's a statutory definition for bothies within the STL licensing legislation. So again, notwithstanding the fact you may call your property a bothy, it has to come within the definition which is laid down in the STL licensing legislation to be excluded from requiring a short-term let license. Accommodation which is owned by an employer and provided to an employee in terms of a contract of employment or for performance of the employee's duties. And there's also a number of other tenancies that are excluded. So this includes long-term lets under a short assured tenancy or private residential tenancies or other agricultural type of leases. So our first frequently asked question that we've been asked, which I think is especially pertinent in the Highland Council area: I operate an STL accommodation on a croft. Do I still require an STL licence? So whilst a crofter's arrangement with their landlord may be excluded from requiring an STL licence, any accommodation which is offered on a croft which otherwise comes within the definition of an STL property may require a licence, notwithstanding the fact that such property is on a croft. So effectively, just because the property accommodation is on a croft, you may still require an STL licence. What if you only operate your property as an STL for part of the year? Do you still need a licence? The short answer is yes. Unless one of the exemptions apply, then regardless of it only being offered for let for part of the year, the property will require an STL licence. The guest houses need to apply for an STL licence. So I mentioned a few moments ago the exclusion which applies to hotels. So hotels don't require to apply for an STL licence. So the Scottish Government have confirmed that guest houses are within scope of the legislation and therefore need to apply for an STL licence. The Scottish Government clarified that the exclusion for hotels will only apply if the following two conditions apply, and that is: one, the premises operate as a hotel, and that's a factual question determined based on the facts and circumstances for each premise. Reference was made to the Scottish Government, to the Scottish Assessors Association, and the different classifications they have for hotels and guest houses. And the second condition is that the premises have planning permission granted for use as a hotel. So guest houses and hotels both fall within Class 7 of the Town and Country Use Classes Scotland Order 1997. So guest houses which have an alcohol premises licence which covers the footprint of the STL accommodation and which the accommodation listed within their operating plan, as we've already discussed, don't require an STL licence. So that may cover some guest houses which have an alcohol premises licence in place. So moving on, who can apply for the license? So it could be the host or the operator, the solicitor acting on behalf of the host operator, the letting agent or property management company acting on their behalf. And if the applicant does not own the premises or they own it jointly, then they must have the consent of the owner or each owner to make the application. So are licenses transferable? And I think we can discuss this in a bit more detail as we go on. But the short answer is no, they're not transferable. They're personal to the operator and host, and a new operator host will have to apply for their own license, and that's by virtue of what's stated in the legislation itself. Can you apply for an STL license without yet being the owner of a property? Well, the Scottish Government provided guidance on this point, and they advised that a person who is not the owner of the property can make the application for an STL license if the applicant exercises control over the occupation of the property. So when an application is made by an applicant who's not yet the owner, the applicant must provide the licensing authority, such as the Highland Council, with evidence by way of a signed declaration that they have the consent of the existing homeowner to make such application. But as a new host operator, they must demonstrate compliance with the license conditions as part of their application. So this could be used in a scenario where there is a sale and purchase of an STL. So we've just mentioned that STL licenses are not transferable, but it could be that in a sale and purchase scenario that a purchaser may wish to apply for an STL license without yet being the owner of the property if, as it says in the slide, they exercise control over the occupation of the property. And again, happy to have further discussions about this in the Q&A session. So there's 4 different types of short-term let licenses that can be applied for. So the first is home sharing. So that's where you're letting out all or part of your own home for short-term lets whilst you are there. So the example of that would be renting out a spare room within your home. Home letting would be where you let out all or part of your own home for short-term lets whilst you are absent. Home sharing and home lettings where you do a combination of 1 and 2 above. And secondary letting is where you let out a property where you do not normally live. So that could be an annex to a house, or it could be a glamping pod in the garden of a house if it can be booked separately. Secondary letting does not just mean second home. It can be properties where it'll be effectively a property where you do not normally live. And as you can see, the example of a glamping pod in the garden could be a secondary let. So moving on to, does a site which has more than one premise require one license or a license per property? So multiple properties which are operated by the same host operator as an STL can apply for the one license if all properties meet the following conditions. Number 1 are on the same site. Number 2 are under the one title deed. Number 3 have the same postal address, and number 4 are used for the same type of letting. So for example, secondary letting. If they meet the above conditions, then one license application can cover multiple properties. If not, then multiple licenses will be required. So what we've said from a practical point of view, if you're applying for multiple properties under the same license when you're filling in the application form, if you can select the option of unconventional accommodation on our online application form, I appreciate it could be that you're applying for multiple properties which are not typically seen as unconventional accommodation, but if you select the option of unconventional accommodation on our online application form, then that will enable you to list the details for each individual property. So if you operate a self-catering unit which is annexed to your own house, is that considered to be home sharing, home letting, or secondary letting? So if the unit is capable of being let out separate to the main house, that is, it has its own entrance and guests are not sharing household facilities such as cooking, toilet, or personal washing facilities with the host, then it will likely be viewed as secondary letting. If the unit does not have its own entrance and shares household facilities with the main house, then it's likely be home sharing or home letting. And again, happy to discuss this in a bit more detail as part of the Q&A. So there's 2 different types of premises for short-term let. So the first is dwelling house. So that's where it's an independent dwelling with its own front door, kitchen and bathroom, such as a house, flat, cottage, etc. And unconventional accommodation. So that's effective accommodation, which is not a dwelling house. So that could be a glamping pod, yurt, a tent, a hut, etc. There's also 2 different categories of applicants. This is very important. The distinction here is very important, and I'll come on to discuss this in a bit more detail. The first category is existing host operators. So that's where the applicant has operated the accommodation as a short-term let prior to the 1st of October 2022, and they can evidence that by way of previous bookings receipts as part of their online application. The second category is new hosts and operators, and that's where the applicant has not used the property they are applying for a license for a short-term let before the 1st of October 2022. Now, it doesn't matter that the applicant has already operated other properties as a short-term let, or that the property itself has been used as a short-term let before the 1st of October 2022. It's the application property being operated by the applicant themselves that determines the status. So, one of the reasons why the distinction there is so important is in terms of the timescales. So for new host operators, from the 1st of October 2022, they need to have a license for short-term lets. They can advertise, but they can't take bookings or receive guests until they've obtained a license. For existing host operators, they have until the 1st of October 2023 to apply for a license if the accommodation was used as a short-term let before the 1st of October 2022. So the applicant can continue to operate without a license by continuing to take bookings and receive guests unless their license application has been determined and refused. And a very important point on the slide here, an existing host operator will lose their existing host operator status if they don't apply by the 1st of October 2023. So if for example, if they don't apply by the 1st of October 2023 and they decide to then make an application in, say, January 2024, then even if they had been operating prior to the 1st of October 2022, that applicant would then be deemed as a new host operator when they came to make their application at a later date by virtue of the fact that they hadn't made their application by the 1st of October 2023. So the timescales are also important. The distinction is also important in terms of the timescales. So the council has 9 months to determine an application for a short-term let license from a new host operator, and 12 months to determine an application for an existing host operator. Now, we want to process applications as quickly as possible, and these are the maximum timescales which are set out by the STL licensing legislation. I should say that we'll prioritise applications by new host operators and those for temporary licenses, which I'll come on to discuss shortly, since new host operators effectively can't operate without an STL licence. So existing host operators are allocated a provisional licence number which allows them to continue to operate until a decision is made on their licence application. License can be granted for a maximum of 3 years, and then licence holders need to apply again to renew their licence, and ultimately operating without a licence when required is a criminal offence. So I've put on the screen details of the application fees for how much it costs to apply for a license. This is, as you can see, it's based on guest capacity and the type of letting. You can see details of that on the screen currently. I'll just leave that there so everyone can have a wee look at it. I should say that the application fee is due at the point of the application being made. The application can't be processed until the fee is paid. We can't start to process it. I should also say it's not an annual fee. It's a fee that's paid that would cover the 3-year period of the license effectively. So it's not an annual fee. It's made at the point of the application, and if granted, covers the 3-year period of the license fee. The fees are non-refundable, and again, happy to discuss any points in the Q&A session at the end. So I'm applying for multiple properties in the same STL license. How do you calculate the occupancy for the properties and the fees to be paid? So the max occupancy for all properties combined should be stated in the application form. The fees then calculated on that basis. So I've used an example of 6 glamping pods, which each sleep a maximum of 2. So that in that scenario, the max occupancy would be stated in the application form as 12, and then the fee calculated on that basis in turn. So in that scenario, each floor plan that's submitted for each property should confirm the maximum occupancy for that property. So moving on to look at full licenses or temporary licenses. So the majority of operators will be applying for and indeed have applied for full licenses. And as we said, they can be granted for a maximum duration of 3 years. Some may wish to apply for a temporary license. So that can be granted for a period of up to 6 weeks. The application process is very similar, except the statutory objection period, which I'm going to come on to discuss, doesn't need to be followed. And there's no site notice that has to be displayed either, which again we can discuss in a wee bit more detail. Temporary licenses must comply with the license conditions in the same way as the full STL licenses. And I've just put in a point in the slides to say temporary licenses are not provisional licenses. So you still have to submit the same information and the same documentation for a temporary license. Host operators may apply for temporary licenses to cover a specific event should they wish to, for example, rent out their property to test to see if they want to do short-term lets on a longer-term basis, or if it was for a specific event. License fee is 50% of the full fee. So there's also temporary exemptions within the legislation. The legislation allows councils to nominate specific events within their area which would not require hosts to have a license to provide short-term lets. So the Highland Council's opted to not allow these, and this will be kept under regular review. The temporary exemptions, examples which were discussed, where I think the like European Football Championships, the COP26 when it was in Glasgow, Golf Open Championships, that type of thing. So license conditions. So moving on to discuss these. So these are all licenses are granted subject to conditions the license holder must adhere to. So there's two separate sets of license conditions that apply. So there's a set of mandatory conditions, and they are set by the legislation and apply to all short-term let properties across Scotland. So I've put on a link on the slides, and I should say I'm happy to circulate the slides after the presentation today. But I've put a link on the slides, and that gives you a link to the Highland Council's website that details the mandatory license conditions. So I would say that I would encourage everyone to have a look over the mandatory license conditions before you apply. A lot of the information and documentation that we ask for on the application form is based on the license conditions. So in terms of the mandatory license conditions, and I wouldn't propose to go through these in any great detail, there are conditions regarding fire safety, regarding gas safety, electrical safety, water safety, both in terms of private water supplies and Legionella, safety and repair standards, points about maximum occupancy, and the information to be displayed and to be made accessible to all guests. There's points regarding listings, regarding insurance, regarding the payments of fees, and regarding planning permission when the property is in an STL control area. So that's the mandatory license conditions. As I say, they apply to all properties, all STL properties in Scotland. There's also the additional license conditions. So they apply, they were agreed for short-term let properties and apply to those properties in the Highland Council area. So I should say, if you're watching the seminar and if you're watching the webinar and you have properties which are in another local authority area, then you should double check that with that local authority which additional conditions apply, because the additional conditions which I've included reference to on the screen, which I can discuss, are those which are based in the Highland Council area. So in the Highland Council area, this has points regarding material changes, so to notify the Highland Council of any material change of circumstances, which could include, for example, details of criminal convictions incurred by the person since the granting of the licence, the reporting of certain incidents. So that could be, for example, for the properties had an incident which has resulted in structural damage or collapse or gas leaks, fires, explosions, that type of thing, which has necessitated the call out of the emergency services. It's got points regarding noise and antisocial behaviour, privacy and security, littering and waste disposal, preventing damage to the property, provisions if there's a hot tub at the property. And I would again encourage everyone to have a look through the additional conditions and look over those which apply, and look over those in more detail in advance of making an application. And if anyone's got any questions, I said I'm more than happy to address these in the Q&A. I've just put on the slide there that the mandatory conditions, what they apply to, and as I say, I would encourage everyone to have a look over those. The next slide just has a quick list of those on the additional license conditions, but a lot more information is contained on our website in terms of both sets of conditions. When can you make an application for an STL license for a new build property? So we've been asked this question where the property has been a new build or where the property is in situ and hasn't been completed or hasn't been built yet on the land. So what we've said is some mandatory conditions which are laid out in the legislation can only be met once the build of a property is completed. So we'd advise that an applicant should apply as soon as possible after those conditions are met. Apart from anything else, if the property isn't there, our environmental health team, as part of their statutory consultation, may wish to come out and visit a property, and they can't visit and inspect the property if the property isn't there. So we would say an applicant should apply as soon as possible after they can meet the conditions laid out in the legislation in terms of the mandatory conditions. So in terms of planning permission, so Scottish Government also introduced new planning legislation that was alongside the licensing legislation, and that's dealt with by the planning department, and that forms part of a separate legislative regime. Planning permission may be required depending on individual circumstances for an STL property. So it could be that you may still require planning permission for your property, notwithstanding that you may have a license or have applied for a license. So whilst the new licensing legislation focuses on safety aspects of a property, whether the applicant's a fit and proper person to hold a license, the new planning legislation is designed to address the number of houses and flats being taken out of full-time occupation and used for short-term let accommodation. So the legislation allows councils to designate short-term let control areas. Now, at the moment, Ward 20, Badenoch and Strathspey is proposed as a control area, and we await further legal advice on the exact scope and applicability of this. A planning circular was released by the Scottish Government prior to our designation of the control area, and we were required to take legal advice in terms of that planning circular and how that interacted with the scope and applicability of the said designation. Once the position has been confirmed, we'll update our website and our guidance, and we'll confirm once the control area has been designated. So do we need planning permission for our property to be in place before we can apply for a license? So except in a control area if designated, and that is subject to, as I say on the last slide, that's subject to further confirmations being received. There's no requirement to evidence planning permission as part of an initial STL license application. Now, whether planning permission is required for your specific property is a separate legislative matter, and similarly, whether planning permission is likely to be granted or refused is a separate matter, and that's something that you may wish to seek advice from our planning department on separately. So pre-application advice and development inquiry forms available on the Highland Council's website, and I've put up a link there is to give further guidance on how planning permission applies in relation to STL properties. Now moving on to look at how we process an application. So the main considerations for the council when processing a short-term let licence application, and these are set out by the legislation, are number one, is the person a fit and proper person to hold a licence? And number two, are the premises suitable for short-term lets having regards to, and this is lifted out of the legislation effectively, the location, character and condition of the premises, nature and extent of the activity, kind of persons likely to be in the premises, possibility of undue public nuisance, public order, public safety, or any other good reason. So looking at these in a wee bit more detail, how does the council establish if a person is a fit and proper person to hold a licence? So for short-term lets, it involves looking at whether the owners, the agents, or any named day-to-day managers have any previous conviction, or if there's any information about them that means they would not be suitable to hold a licence. And to establish this, we need to consult with Police Scotland so they can carry out a background check. In terms of how the council establishes if the premises are suitable for short-term lets, we establish a lot of this from the information that we ask for in the application form. That's why effectively we ask for information on the application form, is to help establish that the premises are suitable for short-term lets. We also require the expertise of other services within the council to confirm that they're happy with some of the information that's been provided, and therefore consultation takes place with the council's environmental health and building services departments documents on the application. Scottish Fire and Rescue Service are also a statutory consultee, and they may also require to be consulted on the application. That depends on what information the applicant themselves declares within their application form. There's a fire safety checklist which the fire service provided to us, and which they requested that we could include within our application, which we've done so. And as I say, Scottish Fire and Rescue Service are a statutory consultee. Um, The next point is that members of the public also may have information in relation to the premises, and they've got the opportunity to comment or make an objection in relation to an application. So in order for that to happen, applicants are sent a notice once they've submitted their application, and they must display this at their premises for a period of 21 days. The applicants must then return a certificate of compliance to confirm that they've displayed the notice. Now, we'll prepare the site notice and send that on to an applicant, and we'll also prepare the certificate of compliance and send that on to an applicant as part of the processing. So turning to what supporting documents applicants need to provide with their application forms. The first one is floor plans. So this is required so that we can assess the maximum number of guests that can be accommodated safely. And you've got a bit more information in the slide there about the information that we look for. So we don't require professional plans, but if you can't provide professional plans, then we will accept hand-drawn plans, provided they're reasonably to scale or adequately dimensioned. And ideally, they should include a plan of each floor to a scale of 1 to 50, and have shown elevations to a scale of 1 to 100. As you can see, the floor plan should include references to sizes for all rooms, fire escape routes, accommodation for guests with mobility impairments, location of smoke and heat detectors, carbon monoxide detectors if there's an open fluid appliance fitted, outline of the short-term let property in red, and the max occupancy capacity of each STL property. And as I put in the slide, if you can provide a key for any symbols on the plan. I think at this point I should say that the processing of the form is done by clerical and admin assistants, as well as the licensing officer. It's not done by any way of artificial intelligence. Therefore, if, for example, you've made a mistake on your floor plan, then as part of the processing of the form, one of our admin or clerical assistants will come back to you and say, for example, you've missed out the fire escape routes on your floor plan. Would you mind marking them up, send the plan back on to us, and we can then get this sent out to our statutory consultees. So as I say, it is very much a human-based process. Other supporting documents that we need are a site plan, which includes the boundaries of the STL, but ideally to a scale of 1 to 500. If you're unsure, you can send a copy of a proposed site plan that you're going to submit on to us at our email address, which I'll put on at the end, and we can have a look over that and get back to you. An electrical installation condition report, so that doesn't apply to properties with no electrical fittings or items within the property which are not for guest use or to which guests are not permitted to have access to, and the report must be dated within the last 5 years. A gas and safety inspection certificate, so again, this doesn't apply to properties which have no gas installations. The inspection must be carried out by a gas safe registered person. The property has a gas supply and must carry out annual gas safety inspections and hold a current gas safety certificate. We also require site of buildings insurance for the STL property, and booking and payment details from customers if you're applying as an existing host. So to put up here, we don't require personal details of the guests or bank account information, and booking records from September 2022 or the previous months would suffice. So the next couple of slides, I've got information about what you'll be asked to declare within the application form. I'll just leave these slides on so that people can have a quick look through them. But as I say, the slides will be circulated, but I'll just leave these on screen for a few moments. And just a quick follow-up on some of these points. A PAT test report, we don't have to see sight of the PAT test report when the application is made. The environmental health team may ask for a copy of that as part of their consultation. And indeed, as you can see, the declaration has to be made within the form that it has been provided. And I think the similar point here can be made regarding the EPCs, which I think is on the next page. In terms of a valid EPC, so we don't have to see a valid EPC with the application. It doesn't have to be submitted, but again, our environment and health team, it may ask for that as part of their consultation. I'm happy to go through any of these specific points as part of the Q&A. So in terms of an EPC, do I require an EPC for my STL property? It's a question that's been asked a lot over the last year. The relevant legislation states that an EPC is not required for standalone buildings which, one, have a total useful floor area of less than 50 metres squared, and two, are not a dwelling. So dwellings defined for the purposes for the EPC purposes as a unit of residential accommodation occupied whether or not as a sole and main residence by an individual or individuals living together as a family, or by not more than 6 individuals living together as a single household, including a household where care is provided for residents. The main question, therefore, is whether a property can be classed as a dwelling, and if not, it won't require an EPC. And I've put a link to some Scottish Government guidance on that. It's also important to know an EPC is not required for STL licensing purposes. An EPC is not required where only a room within a building, such as a hotel room or guest room, is being let. So again, other presentations we've been asked very specific questions about fire safety checklist or about fire safety and how it applies. So unfortunately, we cannot provide any advice on fire risk or the fire safety checklist. We'd recommend all applicants review available guidance from Scottish Fire and Rescue Service. They're a statutory consultee and they're the authority for fire safety. And we've put up some links to some Scottish Government guidance, which may be helpful also. Where can you find guidance on completing the Legionella risk assessment? So there's guidance on the Health and Safety Executive's website, and that we would encourage everyone to have a review of that. Now, depending on the circumstances and whether an individual feels competent to do so, there's a risk assessment to be completed, and that's to be completed by the host operator themselves. The risk assessment, sorry, can be completed by the host operator themselves, and it doesn't have to be completed by an independent assessor. We've got a style risk assessment which is available on the Highland Council's website, and that can be downloaded and completed if an individual feels competent to do so. So what happens if an application has objections? So these could be, for example, from police, they could be from the fire service, environmental health, building standards, or indeed from members of the public. So some of them could be resolved by the applicant providing further information, which allows a consultee to ultimately withdraw their objections. So perhaps a consultee will object on the basis of will object, and the applicant may be able to provide further information or documentation to the consultee, which ultimately they're then satisfied with, and they'll then withdraw their objection. Some objections may not be able to be resolved. So, for example, a police objection letter based on conviction an applicant has, or if there's a member of the public complaining about poor management to date of a short-term let property. So, in those cases where there's unresolved objections or representations, the application cannot be granted by the licensing team under delegated powers, and it's required to go to a hearing in the Highland Licensing Committee. And that hearing, that's where the councillors are on that committee determine whether a licence can be granted or not. Now, there's quite a bit of information about the process and how an application is determined within our policy statement. I've put a link to that on the slides. So what if you have one objection? Does that result in your application going to a hearing? Answer is, regardless of the number of objections, an unresolved objection is required to go to a hearing before the licensing committee to determine the application. If you wish to make an objection or representation in connection with a license application, where to find more information? So there's more information on a guidance document which we've provided, and I've put a link to that on the slides, and that's on our website. Effectively, that takes information from our policy statement, which is for those who wish to make an objection or a representation in connection with an application. On what basis can your application be refused? So an application for an STL licence can only be refused on the statutory grounds which are set out in the STL licensing legislation, and they're on the screen. So namely, number one, the applicant or anyone else detailed in the application is not a fit and proper person. Number two, the activity to which the licence relates would be managed or carried on for the benefit of a person other than the applicant who would be refused such a licence if they'd made the application. And as you can see, where the licence relates to an activity consisting of or including the use of premises. Those premises are not suitable or convenient for the conduct of the activity having regards to location, character, condition of the premises, nature and extent of the proposed activity, kind of persons likely to be in the premises, the possibility of undue public nuisance, public order, public safety, or there's another good reason for refusing the application. It's important to also note the terms of an objection or representation should be relevant to the matters the Highland Council can take into consideration in determining an application, and frivolous and vexatious objections and representations should not be considered. So while you have a chance to state your case at a hearing, yes, all interested parties will be given the opportunity to state their case before the licensing committee. At a hearing, there's a procedure that is followed, and more details than that are found at Annex 2 of the policy statement, and it's worthwhile reading through that, particularly if there are objections which come in connection with an application. So enforcement. So how is the legislation going to be enforced? So for unlicensed properties, it's a criminal offence, and enforcement is ultimately a police matter. For compliance issues with a licensed SDL property, it'll be investigated and dealt with by the council's environmental health team. So for example, if there's an allegation that someone is not complying with a condition within their STL licence, then it will be investigated and dealt with by the council's environmental health team. What happens if you operate an STL property without an STL license? So ultimately, it's a criminal offence to carry on an activity for which a license is required without having a license and without reasonable excuse. I've put on some useful links here as well. There's a lot of information on our website. We've spent a lot of time updating and keeping up to date the information which is on our website. A lot of further guidance on there. There's also information on the licensing fees, which we discussed a few moments ago. I've put a link up to the Scottish Government's guidance on STL licensing. It's got a link to some frequently asked questions. Some of those we've went over today, but there are some others on our frequently asked questions. We've also put up some links to planning permission as well. And where do you complete the STL license application form? So a link to the application form is found on our website at highlandgov.co.uk/short-term lets. What happens if you make a mistake in the application form? So during the presentation, I said it's human beings who are effectively processing the applications. It's not artificial intelligence. If you make a mistake on your form, then please send an email to the stl@highland.gov.uk email address. As soon as you realise that you've made a mistake, include your full name, organisation's name, full address details of the STL, the application reference number, which is an FS reference number, and a note of the mistake that you've made in this email. This can then be noted with your application form. As you'd imagine, with the upcoming deadline of the 1st of October 2023 for existing hosts, we are dealing with a huge volume of inquiries at the moment. We've got a huge number of emails get into our STL inbox, but if you realise that you've made a mistake, please send on the email and we can track that with your application. And as I say, I've put on the contact email address here. And the final thing is just any questions. So I think we can move on to our Q&A session. So yes, so I'm happy to pass that back for the